10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hel- Hello, my friends, and thank you so much for coming to hang out with me on this Tuesday, December 19th. I appreciate you so much, and a special little shout out to my daughter Scarlett and her friends Alexis and Christina who are watching from the high school cafeteria. So, I don't know if you guys are supposed to have your phones out, ladies, but if it's okay, then thank you for watching and tuning in today because I love how when I come into the high school, people come up to me, kids come up to me and say, "Oh, I'm such a big fan of yours." So not only, peeps, do we have the 55 plus crowd here, which I know are the majority of my viewers and my demographic, we also have some high school girls who like this show as well. So yay us, we're doing something right. We get them all. We get all the demographics. Oh, thanks, Scarlett. I'm glad that it's okay. Don't get in trouble. Don't get any sort of write up or demerit on my behalf. But I do appreciate you guys' support. And as always, thank you for watching. So, as always happens when I plan a show, other stories break. And so, we have some good news today in Florida. Thank you to Susan, one of my viewers, who emailed me this right before the stream. And I don't know if you guys know about this yet. So we are going to give it a few minutes to let some people join because sometimes I say to you, do you think anybody's listening to us? Do you think anybody's listening to us? And I think the Florida legislator might have heard some of the stuff that we had to say. So this is pretty exciting. I got to be honest, I don't know how much of you guys have heard about this, but there is a new law that is going into effect on January 1st with regard to the DCFS system in Florida. And we are going to talk about that in a second. I just want to see what we have going on here in the stream because I have YouTube up on another thing. I'm going to be really, really just bland for the first 5 minutes because while I did a live stream yesterday on the Ruby Frankie hearing that was supposed to happen, that we didn't actually get live streamed, and then talked about it anyway for about an hour and a half. And during that live stream, certain documents were dropped, like the actual plea bargain, which I only read the first page of to you, but the second and third pages of that plea bargain, the things that she admitted to, the facts that she admitted to about the horrific acts that she committed on her own children were blood curdling. And I'm sure if you watched that coverage in other places, since a lot of people streamed that after I did, they had access to those documents and read them on air. Well, I will say that I thought my stream yesterday was pretty benign. Didn't really get into a lot of detail, didn't really get into a lot of the allegations, and it wasn't graphic in any way. But in typical YouTube fashion, that stream was immediately demonetized as being unfriendly to advertisers. So I quit. I quit. What is the point? I watch creators, and I watch a lot of creators on YouTube who are dropping the F-bomb every 3 seconds. And I wonder, is this just a topic problem? Are we not allowed to talk about the law involving things like CA? Is it the word that's offensive? Because there are a lot of other words that I hear on YouTube all day long. And I'd love to talk to those creators about whether or not they're being immediately demonetized as, quote, unfriendly to advertisers. And it always happens. You can appeal it. Sometimes they reverse it. But if it happens after the first 10,000 or 15,000 views, I don't believe that it's retroactive and you don't get any ad revenue, even though they still show ads, but tell you it's unfriendly to advertisers. And then you have those 10 or 15,000 views or 20,000 views sometimes by the time they actually take a look at your stream to figure out that there was nothing wrong with it or offensive. And hey, I'm just a law tuber sitting out here trying to teach people about the law and explain legal documents to them. But Sometimes the charges are the charges. Doesn't make it unfriendly to advertisers. We're just talking about cases that are in the news. And that may be the next soapbox that I get up on is some sort of case against them. Because if that's true, there are a lot of creators losing money while YouTube is still getting the ad revenue. So I guess I shouldn't say that either, or they will definitely demonetize me. I have no idea. I don't know why. I don't know why either. Cheryl, I don't know. But if you know and you watch a lot of other creators, you know that a lot of other creators have a lot of language. They use a lot of language. I don't use the language. I don't like the cursey words. You guys know that. We keep it classy in the chat. I don't curse. You guys don't curse. We're not anything that is offensive is deleted or people are muted or blocked. We don't tolerate it. We don't tolerate the vitriol and the bullies. So I don't know either. I can always use code. I know, but I do. And I did, Henry. I did that. I did a stream the other night that my mods asked me to schedule because they had surprise Christmas gifts for me. And I opened some Christmas gifts that were all very clean gifts. That show is demonetized too. So there is no rhyme or reason to it. AI is apparently not your friend because that show was incredibly benign. Incredibly benign. So I listen, if I could figure it out, Kurt, I see you're out there. Kurt, I don't know if it's happening to you also, but I'm saying there could be a class action against YouTube for all of the demonetization that may be arbitrary and capricious. And there are a lot of YouTubers that could be losing money because you know how it goes, Kurt. You get demonetized and then after the first 10, 15, 20,000 views, all of a sudden they reverse it, but it's not retroactive. So that's my little rant for the morning before I have some good news for you. Some good news. We totally, let's see, a lot of creators don't bother to monetize their stream. Also, some don't swear until after 2 hours. Some just hope it works. Yeah, I always appeal it. And it always gets overturned. The only one that did not get overturned was the Matthew Perry one. Matthew Perry's demise. And it's because I had 2 words in the title that YouTube doesn't like. And despite the fact that they were 2 words that my viewers and I and the therapist that was on the show with me were trying to help people with those problems, it still apparently is unfriendly because you can't even try and help people who have certain problems if you use the actual word of the problem. So I don't know. I don't know what the deal is, but we'll figure it out maybe one of these days. Here is some good news coming out of Florida, my friends. There are 4 new laws taking effect in January. Here's what they may mean for you. And thank you to my viewer, Susan, who emailed this to me right before the stream started because I had not seen this. Was in today's Miami Herald. SB 7056 puts the state's Department of Children and Families in charge of handling abuse investigations. All right, hold on. I'm going to read that again because it wasn't big enough for me to read it on this screen, and I'm looking at this screen. SB 7056 puts the state's DCF back in charge of handling child abuse investigations as opposed to leaving that duty to 7 Florida counties that had assumed that role previously, including the Broward Sheriff's Office and Pinellas County. So, my friends, as of January 1st of this year, DCF will no longer be privatized in Pinellas County where the Maya case took place. Is that not amazing news? Somebody may actually be listening. And here is the law about child abuse investigations. And excuse this website because it likes to jump around. This law requires that the 7 Florida counties that were handling child abuse investigations instead of the DCF give those responsibilities back to the state. Counties named. These 7 counties will give control to the DCF to perform child protective investigations by January 1. Broward, Hillsborough, Manatee, Pasco, Pinellas, Seminole, and Walton. What to know? According to the Senate's analysis, the sheriff's office's total amount for Child Protective Investigative Services devoted to the 7 counties' sheriff's offices was just over $59 million. The Broward Sheriff's Office had the largest chunk of that funding at just over $15 million. In April, the DCF reported in a bill analysis that in the 2 decades since 1988, that the state started allowing the specified sheriff's offices to perform child protective investigations, Florida's child welfare system has evolved and recognized DCF's, quote, renewed commitment to prevention-focused programming, end quote, as some of the reasons for the switch over. The bill also specifies that all staff who are in good standing and employed by each respective sheriff's office for the provision of child protective services before January 1, 2024, when the law goes into effect, can have the option to transfer their employment to the DCF. And that, my friends, is a little bit of good news on this December 19th. What say you, my friend? What say you? Correct, Jules. No more double dipping for Sally Smith. I wonder if she will, come January 1, be unemployed. The people have spoken, Nancy McCarthy. The people have spoken. That's a good one. Rumor has it Murdoch is going to be running the Florida DCF. Yeah, from his prison cell. Wonder if he'll be in Club Fed by that time or if he'll still be in the prison that he's in. Yep. Finally, somebody gets it, Danielle Alexander. Finally, somebody gets it. Somebody gets it. Ruby, is that good news? No one can sue the state, right? Well, they couldn't sue the state before because everyone had immunity. There's still Chapter 39 immunity, but what that means is that the DCF system in those 7 counties, I thought it was 6, but they said 7 counties in Florida, will no longer be privatized. And we've discussed this before, that Sally Smith was employed by a private company, and therefore she wasn't making money unless she was needed, etc., etc., etc. So JC says, I can't believe SS is allowed anywhere near children. I do not know if she is or not. I do not know the status of Sally Smith's employment currently, but I do not think that she is part of the Schuhstaffel. So congratulations to Florida for finally getting with the times and eliminating the privatized DCF system in those 7 counties in Florida, including Pinellas County, effective January 1. And here, my friends, is the actual law. Which is Senate Bill 7056 about Child Protective Investigative Services, which will take effect, like I said, on January 1, 2024. This was the general bill by the Appropriations Committee on Health and Human Services. Child Protective Investigative Services, repealing provisions relating to sheriffs of certain counties providing child protective investigative services, requiring certain sheriffs to transfer the functions of providing child protective investigative services to the Department of DCF, providing that certain sheriffs remain the custodians of certain files and documents, authorizing the department and certain sheriffs to enter into an agreement to allow certain employees to remain in office space owned or leased by the sheriff for a specified time, etc. And so, while sometimes we may feel like we are yelling into a YouTube void, perhaps somewhere people are actually listening. And that's a great feeling. And we know they're listening also because some of our exhibits, some of our arguments, some of our theories have ended up in court papers, and some people have been named. But some people's graphics have been used. I did do a whole thing on the Schuhstaffel lettering with regard to certain logos that wound up in the motion papers, some of my ideas, but then somebody else told me that it was actually their graphic that they had posted in the group that was actually used, and she was very proud of herself. And I am very proud of you too, As a college student, you did an amazing job, and it showed because some very important lawyers took your graphic or asked you to use it or whatever they did, your idea, and it was used in some very important motion papers. So there. Somebody's listening. So something else dropped this morning, and that is the judge's order on the immediate jeopardy information. So we're going to take a look at that first because that is hot off the press this morning. If I can figure out where I put it on my screen. Talk amongst yourselves in 1 minute. And here we go. This is the judge's order. It was filed this morning. Okay. This is in the matter of Kowalski versus JHACH. This is an interim order on the immediate jeopardy documents. Near the conclusion of the trial in this matter, an issue arose concerning what is being referred to as the immediate jeopardy finding associated with an accreditation entity's warning, referred to as the immediate jeopardy finding associated with an accreditation's entity warning to Johns Hopkins All Children's Hospital that it may lose its ability to receive federal funds. The court ordered the expedited production of documents as to the immediate jeopardy issue. JHACH sought reconsideration, which the court denied, and directed the immediate production of the immediate jeopardy documents. Some, but not all of the documents were produced prior to the close of the plaintiff's rebuttal case at the deposition of a JHACH corporate representative. Deposition, but JHACH did not turn over the balance of those documents. The court again directed the production of those documents. Apparently, JHACH brought 2 banker's boxes of documents to court on the afternoon of Thursday, November 9th, 2023. Nearly concurrent to their arrival, the jury announced that it had a verdict. After taking the verdict, the court began the punitive damages phase of the trial. Plaintiffs report that they did not have time to review the documents. And after the jury rendered its verdict in the punitive damages phase, the court discharged the jury with the consent of the parties. JHACH took those immediate jeopardy documents with them without turning them over to plaintiffs. Plaintiffs still seek the documents and has filed a motion to that effect, and JHACH has continued to decline to turn those documents over, now contending that there is no point in light of the jury's verdict. Plaintiffs contend that the documents remain relevant for the sanction motions as well as to dispute certain JHACH positions in their post-trial motions. During the post-trial motion hearing and discussion of various sanctions issues occurred, plaintiffs report that JHACH recently delivered a privilege log of the immediate jeopardy documents. JHACH again objected to producing the documents, but did not offer to turn over what it contends are the non-privileged documents under the existing confidentiality order. JHACH requested a hearing or a review by the court of the documents it claims to be privileged. This is interesting because clearly, if you wanted to act in good faith, and you know the judge is already annoyed with you for not obeying his order to turn over all documents with even a scintilla of odor, I think is what he said, to now give a list of everything that you deem to be privileged and why without turning over the non-privileged documents as a show of good faith is a little bit not so great. It is therefore ordered. 1, defendant Johns Hopkins All Children's Hospital shall preserve and maintain the, quote, immediate jeopardy documents. This includes preserving them through all further proceedings in this case, whether that is a new trial or entry of judgment without a new trial or some other path, as well as through any appellate proceeding or review proceeding until final resolution of this case through any proceeding in whatever court. 2. Defendant Johns Hopkins shall immediately produce to plaintiffs under the existing confidentiality order the, quote, immediate jeopardy documents to which JHACH does not assert a specific privilege. It says 2 again, but that's misnumbered, and that is the second 2, which should be 3, but for clarity of this reading, I'm going to say second paragraph number 2. Plaintiffs may review the JHACH privilege log and identify for the court the specific documents it contends that it needs for the various sanction issues or post-trial motions. Plaintiffs shall provide that list together with the privilege log to the court's chambers with a copy to JHACH. 3. The court thereafter will then determine how to proceed, which may include an in-camera inspection. In-camera means that the judge will do it by himself outside the presence of everyone and review for himself what he thinks should be turned over. 4. The plaintiff's motion and request for sanctions on this issue remains pending. Done and ordered in Sarasota County, Sarasota, Florida on December 18th, 2023. That just hit the court docket this morning. What say you, my friends? What say you? I don't know if the defense thought they were going to pull something over on the judge by just, thinking he would forget that he ordered them to turn these documents over. But if you did see the list of all those privileged documents, it goes on for quite some time, and it is a very lengthy list with objections to everything. There's usually one blanket objection. We should not have to give you anything because everything is privileged, and who cares because trial's over, but the sanctions part of the trial isn't over. So there's that. Next up, we have the plaintiff's response to the motion, to the things that popped up during the hearing last week on December 15th. So let's take a look at that. If anybody has any specific questions, just hold them till the end, and we will cover the questions at the end. This was filed yesterday, and this is plaintiff's response to what went on at the hearing. Sorry, Sarah, I did not mean. Thank you, Team Brittany, for gifting 5 memberships. I appreciate you so much. And to those of you who received the gifted memberships, you need to opt in to receiving gifted memberships. There is some way to do that. I'm not quite sure how, but I think you hit the 3 dots at the bottom of the chat and you can opt into receiving a gifted membership. And then YouTube randomly distributes them to people who are contributing in the chat. So here we go. It's not cooperating with me. Here's plaintiff's response to defendant's 3rd supplement, proffer of affidavit at December 15th hearing to motion for juror interview. Having failed to articulate any grounds to justify an interview of juror number 1 in its previous motions and supplements, the defendant produced a third-party affidavit at the time of the hearing on December 15th of 2023. Plaintiff's first opportunity to review the affidavit was during defendant's argument on its various post-verdict motions attacking juror number 1. Having withheld the affidavit until the last minute, defense counsel was unable to facially argue that there was a non-disclosure on the part of juror number 1. Astoundingly, this is another instance of defendant willingly and recklessly misleading this court. Let's go to the footnote. The court may recall that at the December 15th hearing, that defense counsel deflected questions raised by the court about whether the defendant had asked questions of jurors based on affirmative responses to the, quote, crime questions on the juror questionnaire. Defense counsel misleadingly responded that he hadn't, quote, gone back through all the voir dire to determine whether the defendant had, in fact, asked questions of jurors who answered any of the crime questions in the affirmative. In responding here, the plaintiff learned that the defendant had never even ordered the transcript of the jury selection process. I'm going to break from reading here for 1 minute to just tell you that this is going to be one of many glaring misrepresentations and or omissions and or outright lies during the defendant's argument of this motion, which we are actually going to take a look at as well, because you and I did not have a chance to go over that hearing last week. And now's the perfect time to play portions of that hearing so we can see exactly what they are referring to in these motion papers. The court. Let me ask you this, and I haven't gone back to look at all the juror questionnaires, but were there other juror questionnaires where the juror checked a family member's been victim of a crime, and then did your side ask questions of those individuals? Mr. Shapiro said, I haven't gone back through all the voir dire, end quote. In fact, defense counsel had not gone through any of the voir dire before making their latest reckless assertions. As discussed further below, having had the $7,500 privilege of ordering the transcripts and performing the due diligence, defendant should have performed before further disparaging juror number 1 and making false claims about what the defendant would have done. Plaintiff can conclusively demonstrate that defendant asked no questions whether or not a potential juror or one of the juror's family members had been charged with a crime, or the victim of a crime was simply not an area the defendant was concerned with or ever explored with any of the 12 jurors during the multi-day jury selection process. See discussion herein. This, in my opinion, and we're going to break from reading this for 1 second again, in my opinion, is not going to play well for the defense. Having made this argument in front of Judge Carroll, who during this hearing did not seem like a very happy camper, in my opinion, but he was trying to keep us cool and he did a great job. The transcript of the voir dire was apparently very lengthy. I don't know how long the jury selection process took. That is what voir dire means. It's when the attorneys and the judge question all the potential jurors while it's jury selection, basically, in this case, in this context. The transcript of the voir dire proceedings must have been very lengthy because when the plaintiff went to order it from the court reporter, which is what must be done when you're arguing things like this, it costs $7,500 to obtain a copy of the voir dire transcript. Whether it was 1 day, 2 days, I do not know. Court transcripts are very expensive. Court reporters can make a lot of money when transcripts are ordered because they get paid by the page. So the fact that they did not even have a copy of the transcript of their own voir dire and yet had the stones to make this argument in open court is mind-numbing. It is mind-numbing to me. We're going to play it in a little bit. We're going to play it because you need to see it. Juror number 1 did disclose on her juror questionnaire that he or an immediate family member had been charged with a crime at question 18B. Juror number 1's disclosure on his juror questionnaire demonstrates that both defendants' first supplement, based on the 20-year-old domestic court issues, and the latest affidavit are frivolous and could have been explored by the defendant. Contrary to defense counsel's assertions during the hearing, defense counsel asked no questions about the crime response at question 18B on juror number 1's form, nor any questions of other jurors who said they or an immediate family member had been charged with a crime, the victim of a crime, or a witness in a criminal case. The record proves that the defendant did not consider the information material, at least until the defendant lost. The plaintiffs pray that this court not reward defendants JHACH for its continued attacks on juror number 1 and multiple bad faith attempts to mislead this court. The defendant has targeted juror number 1 and viciously attacked him, his wife, and now his wife's son in a post-verdict effort to undo a 9-week trial based on post-verdict research into juror number 1's life going back more than 20 years. Let's read footnote number 2. Although defense counsel was uncomfortable divulging defendant's sources at the December 15th hearing, and again dodged the court's questions, defense counsel has turned the netherworld of Reddit into the defendant's research arm and continues to file meritless challenges based on nothing more than the latest conspiracy theory dredged from Reddit. The SS supplement and the proffer of the affidavit are the latest examples. Maybe somebody is listening, because when we went over together supplement number 3, which we will call the SS supplement, I showed you the Reddit thread from which that argument was directly pulled. Directly pulled. So I'm glad someone's listening. To me, or to many of the other people who are out here in the YouTube world screaming about this. Along the way, the defendant has doxed juror number 1, publicly releasing his address with reckless disregard for the safety and well-being of both him and his family. Defense counsel later implied juror number 1 harbors neo-Nazi attitudes and employs neo-Nazi symbology. And throughout, defense counsel has repeatedly misrepresented the record, i.e., the introduction of the phrase, quote, creature comforts into the trial, and now misrepresenting defendant's lack of diligence during jury selection in an all-out effort to destroy juror number 1. Exactly what I've been saying all along. Defendant wishes to cajole this court to allow, quote, just an interview of juror number 1 on fairness grounds based upon defendant's argument that although each of its premises to justify an interview fails individually, when viewed collectively, the false premises must amount to something. The defendant will never stop with just an interview, as defense counsel admitted during the hearing. The defendant has already demanded juror number 1's private communications and text messages, along with those of juror number 1's wife's, along with those of Jules. Hi, Jules. I know you're here. You are referred to in footnote number 3, so let's hear what they have to say about you. 3, even if the court accedes to defendant's request for an interview of juror number 1, the defendant will next press the court for private communications between juror number 1 and his wife on this road to nowhere, since the defendant cannot overcome the husband-wife privilege set forth in Florida Statute 90.504. I agree with them there as well. And Jules, that wasn't about you, but I guess that's a good thing. Fairness extends far beyond the immediate considerations here and will broadly impact the jury system and citizens' willingness to serve on juries if a citizen's entire life will be scrutinized post-verdict simply because a citizen turned juror renders a verdict adverse to a dysfunctional corporate defendant. Been saying this all along too. Who's going to want to serve on a jury if your entire life is going to be turned upside down the second a defendant gets a verdict that they don't like? This is chilling. This will have a chilling effect on the jury system, not just in Florida, but nationwide. And I will tell you that people will walk into jury duty and say, I'm sorry, I watched that Maya Kowalski trial and I saw what happened to juror number 1. And yeah, I really don't want to be on a jury. Just can't do it. Just can't do it. And who could blame them? Not me. Leaving the potential ruinous effects on the jury system and public policy considerations aside for the moment, however, Defendant's latest attempt to call juror number one's service into question based on the last-minute production of a third-party affidavit fails for at least 3 reasons. 1, defendant has not met its burden. 2, defendant's challenge based upon the third-party affidavit is pure artifice, as demonstrated by defendant's pattern of questioning, or more accurately, failure to question during the multi-day jury selection process in this case. And 3, defendant waived any challenge based on the third-party affidavit and public records in the related case. And I guess that answers my question that the jury selection process was multi-day. He does not say how many days, but was at least multi-days. Defendant has not met its burden. Its actions show the question was not material to it. Defendant has again failed to meet the high burden to interview or disqualify a juror post-verdict and set aside 9 weeks of judicial effort. The Florida Supreme Court reaffirmed a 3-part test for whether a juror's non-disclosure of information during voir dire warrants a new trial in Roberts versus Tejada, a Florida case from 2002. For the initial prong, quote, the complaining party must establish that the information is relevant and material to jury service in the case, end quote. Here, defendant contends an alleged non-disclosure by a law enforcement officer that he was a, quote, victim of a, quote, crime, a verbal threat that was material to its decision to keep juror number 1 on the jury. This is demonstrably false. In Roberts, the Supreme Court held that quote, materiality must be analyzed on a case-by-case basis, and, quote, materiality is only shown where the omission of the information prevented counsel from making an informed judgment, which would in all likelihood have resulted in a peremptory challenge, citing another case from 2004. Quote, further, we have studied the record and see nothing in the pattern of peremptory challenges to suggest that Murphy would have stricken juror Moore if the information had been disclosed during voir dire, end quote. And like I tell you, there's always a case. There's always a case to support your position, and you are going to see why that particular case hits the nail right on the head. In other words, under the 3-part test set forth in Roberts, defendant needed to show that juror number 1's responses on his juror questionnaire prevented Johns Hopkins and its jury consultant from making an informed judgment, and that the defendant would have exercised a peremptory or perhaps cause challenge if juror number 1 had checked question 18A yes instead of no. Defendant cannot meet this burden. In presenting the affidavit at the December 15th hearing and attempting to argue some sort of prejudice from the late discovery of a public record, defendant's counsel did not represent that he would have exercised a peremptory challenge even when the court inquired. Footnote 4, which is a link to a YouTube video of this actual thing happening in real time. Defendant was unable to commit to the premise that it would have challenged juror number 1, and the record supports defendant's ambivalence. Juror number 1 did check yes to question 18B, that he or an immediate family member had been charged with a crime. In follow-up, defendant's counsel and its jury consultant asked 0 questions of juror number 1. Had defendant's counsel asked any follow-up questions regarding question 18B, juror number 1 would have disclosed the circumstances described in the affidavit. The simple fact is that defendant's counsel and defendant's jury consultant had stars in their eyes when the first juror, juror number 1, to be brought in during individual questioning turned out to be a former law enforcement officer. Defendant believed that its defense would resonate with a former law enforcement officer who would understand the criminal implications of Munchausen by proxy allegations against Beata, would understand the intricacies of DCF and the dependency court system, and would surely relate to Detective Stephanie Graham. We have talked about that as well, that we surmised and hypothesized that they kept juror number 1 because they thought he was going to be sympathetic to their cause, and that he would have a far greater understanding of the system and would perhaps afford greater weight to testimony of detectives and other law enforcement people and the system. And only when he did not did they come up with this theory, argument, plea, Hail Mary, whatever you want to call it. Defendant did not exercise due diligence as demonstrated by defendant's failure to ask juror number 1 any questions and by failing to challenge jurors who answered affirmatively to crime questions on the juror questionnaire. Lawyers representing clients in litigation are entitled to ask and receive truthful and complete responses to the relevant questions which they pose to prospective jurors. Citing 2 more cases. During defendant's or tennis challenge, based on the affidavit, defendant repeatedly cited to the 3-part test reiterated in De La Rosa v. Zequiera, a Florida case from 1995. Defendant cannot meet the 3rd prong. Quote, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. Citing 2 other cases from 1972 and 1973. Defendant did not ask any questions of juror number 1, even though he answered affirmatively to another crime question on the juror questionnaire, nor did the defendant demonstrate due diligence in asking other jurors follow-up questions when they answered affirmatively to the crime questions on the juror questionnaire. At questions 18A to 18C. Defendant's lack of diligence cannot be used to assail the adverse verdict under both De La Rosa and Roberts. Defense counsel confessed during the December 15th hearing that they had not performed the necessary analysis to demonstrate its due diligence. The record belies defendant's purported concern and newfound position that it viewed the responses to questions 18A to 18C on the juror questionnaire as material to defendant's considerations and informed judgment during jury selection. In fact, of the 12 combined jurors, both primary and alternates, 6 answered affirmatively to questions 18A to 18C. Defendant selected those 6 despite their answers to questions 18A to 18C and asked 0 follow-up questions on the topic. See juror questionnaires of jurors 117, 1997, 106, 137 compared to transcript of jury selection. Selected excerpts, for which they paid $7,500 for the entire transcript, attached as composite Exhibit A. Jurors number 1, 17, 19, and 97 decided this case despite no inquiry by defense counsel regarding the crime questions, and astoundingly, juror number 106, the first alternate and newfound love of the defendant, was among those who answered yes to the crime questions. Still, defendant did not inquire further. Taking these 6 in order. Here's the receipts, by the way. Here's the receipts. How do you get up and argue something in court and just basically making it up because you know there's receipts out there? Did you think the plaintiffs were not going to pay $7,500 to get the transcript to try and uphold a $261 million verdict? Come on. Juror number 1 checked yes to question 18B. During individual voir dire, the court inquired about juror number 1's affirmative response, and juror number 1 disclosed that his stepson had been charged with a crime. Footnote number 5. Had Mr. Shapiro asked any questions in follow-up to juror number 1's truthful disclosure, the defendant could have learned more about the crime that juror number 1's stepson had been charged with. Importantly, the affidavit relates to that alleged crime. Okay? Are you picking up what they're laying down? Because Shapiro in open court came in waving an affidavit with some allegations about juror number 1's stepson threatening a whole bunch of stuff that he clearly could have asked about in voir dire. And instead of doing that, he is now further disparaging juror number 1 by bringing all of this to the public's attention when the time for this would have been during jury selection. Juror number 17 also checked yes. Okay, wait, let me just go back here. Because I just read footnote 5. Defense counsel asked no follow-up questions and in fact asked 0 questions of juror number 1, even though his stepson had been charged with a crime. Juror number 17 also checked yes to question 18B. During individual voir dire, the court inquired about juror number 1's affirmative response, and juror number 17 disclosed that his son had been arrested 5 years ago. Defense counsel asked no follow-up questions and in fact asked 0 questions of juror number 17, even though his son had been charged with a crime. Juror number 19 also checked yes to question 18B. During individual voir dire, defense counsel focused heavily on juror number 19's awareness of the Take Care of Maya documentary and her Catholic religion, but asked no follow-up questions regarding juror number 19's affirmative response to the, quote, crime question. Juror number 97 checked yes to both questions 18A and 18B. During individual voir dire, the court inquired about juror number 97's affirmative response, and juror number 97 disclosed that her son had been charged with a crime in 2014 or 2015. Defense counsel asked no follow-up questions and in fact asked 0 questions of juror number 97, even though her son had been charged with a crime. Juror number 106 checked yes to question 18B. During individual voir dire, the court inquired about juror number 106's affirmative response, and juror number 106 disclosed that his son was charged with a drug crime. Defense counsel asked no follow-up questions, and in fact asked 0 questions of juror number 106, even though his son had been charged with a crime. Juror number 137 checked yes to question 18A. During individual voir dire, defense counsel asked no questions of juror number 137, despite his affirmative response to the, quote, victim of a crime question. Glaringly, 27 of the first 200 potential jurors answered affirmatively to the, quote, crime questions. Defendant's counsel and its jury consultant demonstrated abject apathy and a complete failure of due diligence on the topic of being either the victim of a crime, charged with a crime, or a witness in a criminal case. The record reveals that the defendant failed to follow up on even one prospective juror's answer to the crime questions. Footnote number 6. Plaintiff's counsel has reviewed the transcript of voir dire for all 27 of these potential jurors questioned on days 1 and 2 of jury selection, but does not include all excerpts here in the interest of brevity. And thank you for that, Mr. Anderson. Instead of making this 400 pages, the court appreciates brevity. I'm sure that they do. While defense counsel represented to this court that he was, quote, certain that if juror number 1 had disclosed that he was a victim of a crime, there would have been a cause challenge, and if not, a peremptory challenge. The record reveals the exact opposite. The court cannot take defense counsel at his word for what he would have done because juror number 97, one of the final 6 jurors that decided the case, disclosed that she or a member of her immediate family had been a victim of a crime and charged with a crime. Not only did defense counsel fail to ask juror number 97 any follow-up questions related to her, quote, crime answers, but defense counsel also did not use either a cause or a peremptory challenge, despite vehemently conveying to the court at the December 15th hearing that he would have if it was juror number 1. Mr. Shapiro said, as your honor can imagine, had that been disclosed, that certainly would have led to a cause challenge, if not a peremptory, if a cause challenge was denied. Transcript is December 15th, page 4, lines 21 to 24. The court need look no further than defense counsel's failure to inquire of juror number 97, the red cow juror, for proof that defense counsel would not have exercised either a cause or peremptory challenge based upon an affirmative response to 18A. Juror number 97 checked yes on question 18A, and defense counsel did not exercise any challenge. The record conclusively demonstrates that defense counsel was not focused on affirmative answers to crime questions during voir dire, and defendant's informed judgment was not impaired by anything but its myopic view of ridding the jury pool of all of the women on the veneer. Oh, that's interesting. So they wanted all the women off the panel because they thought the women were going to be too sympathetic to Maya and Beata. Interesting. Since we weren't there for jury selection, we don't know what happened. So I'm going to take his word for it for now. Tellingly, juror number 106, the first alternate juror, also had a son charged with a crime, yet without any knowledge of the circumstances of that crime, the defendant moved to substitute juror number 106 for juror number 1 during trial. Had that scenario played out, juror number 106 would be subject to the same post-verdict attack by the defendant on display here, since the defendant failed to exercise any due diligence in determining how juror number 106's affirmative response to the crime question would have affected his view of the evidence and testimony in this case. In sum, defendant's lack of due diligence cannot be used to assail a verdict adverse to Johns Hopkins. Defense counsel spent more time making clumsy pie analogies during jury selection than exploring the criminal conduct of any juror or any juror's family members. Cry about it. Defendant waived its challenge based on the affidavit. Defendant's, quote, supplement is defective because the verbal motion was not filed within 15 days of the verdict and is thus untimely. Under Florida Rule of Civil Procedure 1.431H. And the verbal motion was not sworn, which the second district holds is required. See Dowd v. State. The defendant has not submitted any sworn allegations regarding the affidavit and the presupposed prejudice, and defendant's statements on the record are counterproductive given that the defendant was unable to represent that it would have conducted its questioning any differently. Defendant's failure here mirrors its failures to preserve its earlier post-verdict attacks on juror number 1. The affidavit has been public record and was at all times leading up to and during the trial. Over 20 years ago, the Florida Supreme Court stated, the court system is already overburdened and does not have the luxury of allowing jury verdicts to unravel or be subject to attack because of information which could have been reasonably obtained before the trial begins. Everything defendant is complaining about is a matter of public record. The defendant cannot use information it could have known ahead of trial and well before the adverse verdict to justify a new trial. Defendant did not deny in its December 15th hearing that it knew of all the items it complained about in its initial motion through counsel Ethan Shapiro and his wife's extensive internet activity. To have known of the conduct and not complained until after the verdict was a waiver. Citing 2 more cases. Defendant's latest effort to justify a new trial and before that, a juror interview based on the affidavit and an alleged non-disclosure of juror number 1 must be denied. If the court grants an interview of juror number 1 and juror number 1 dispels any notion of misconduct or non-disclosure, that will not be the end of this matter. This is not plaintiff's speculation. Footnote number 7. See YouTube video of December 15th hearing at 27 to 29 minutes, available at this link. Rather, the defendant has already admitted this, stating at the December 15th hearing that even if juror number 1 performs perfectly during any interview that is permitted, the defendant will be back to the court with additional discovery requests and will demand the text messages and electronic communications between juror number 1 and his wife and the public observer known as Jules, who defendant pejoratively and erroneously refers to as plaintiff's agent. Footnote 8. As an officer of the court and understanding his obligations to be as open, honest, and forthright to this court as he possibly can be, the undersigned Gregory Anderson states that Jules was never plaintiff's agent or even a friend or acquaintance to him. He never knew who she was or why she was there. His only contact other than a "Hi, how are you?" coming out of the courtroom occasionally was asked her to eat lunch farther down the hallway towards the tail end of the trial to ensure she did not inadvertently disturb the attorney-client privilege by being privy to conversations between plaintiffs and plaintiff's counsel. Conversation lasted less than 20 seconds. In a case where the bad conduct of defendant was on full display, where the defendant elicited false testimony and withheld material information regarding its dysfunction, where the defendant refused to produce cell phones and text communications until 15 hearings were held. And even then, the majority of the phones and text messages were destroyed by defendant and its agents. Now the defendant wants to turn a Florida citizen and his wife into public enemy number 1 and treat juror number 1 as an adverse party in order to enforce discovery standards and compel production of text messages that the defendant would not honor. Took 15 hearings to try and get cell phones and text communications of the doctors and others who were going back and forth, who had predicted Beata's taking her own life, who had referred to Maya as K-girl, and who knows what else, because a lot of those cell phones apparently drowned. You know what they say, what's good for the goose? Not only will any potential juror interview not save the court from defendant's reckless charges of the court abusing its discretion, the defendant will not rest until it has completely destroyed the reputation of juror number one, obliterated the husband-wife privilege, and done irreversible harm on the jury system in Florida and beyond. Pausing for a minute there because we've been saying this. I've been saying this all along. That Hill Ward Henderson will have single-handedly destroyed the jury system in Florida and beyond. The court will have better luck teaching a fish to foxtrot and getting the defendant and its counsel to refrain from filing frivolous motions and litigating and appealing and otherwise doing everything they possibly can to delay the conclusion of this case. Wherefore, plaintiff respectfully requests that this honorable court deny defendant's motion for a new trial based on juror misconduct, motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motions to preserve evidence and all of its various supplements, and award sanctions for the reckless and callous statements within the motion and for any and other further relief as the court deems just and properly, respectfully submitted. Love, Greg Anderson, Raymond Elliott, Nick Ridley, Jennifer Anderson, Amy Farrier, and the firm of Mr. Elliott. I've never heard the expression about teaching a fish to foxtrot. Have you? Have you heard that? Anyone? Hello, Sarah. Thank you. Thank you for your mods. Team Brittany is an amazing mod. Yes, thank you, Sarah, for thanking me. And my mods are amazing. And I wasn't watching the chat because I had full screen on because I had to read that to you. And I had to enlarge the font. So I don't know if anything happened, but I am sure that they put a stop to it. But thank you, Sarah, for your super chat. And thank you, Gary, for gifting a membership. We appreciate that so much here. I'm going to come to you, my friends. Recovery Addict said that was a legal saying, teaching a fish to foxtrot. I've been practicing law for 30 years and I have never heard that before. Ever? I thought maybe it was an old time. What? Johnny Depp, is that real? Hold on a second. I just gotta see if I got any alerts on here. I can't change the stream now. I don't see any alerts. So I don't know. I don't know that's information, but I hope that's not true. Hello, Recovery Addict Raid. Thank you for coming over. Thank you for coming over. I know if there's breaking news, let's not talk about it because I'm not done with this yet. But if there is and it pops up on my thing, we will talk about it. Hello, it's fake news. Is it fake news? Thank you, Jules. Why do people do that to me? It's a hoax. It's always a hoax. It's like Taylor Swift is getting engaged. No. We're not going to believe it. We're not going to believe it. All right. Forget that. I'm sorry I put that up there. And I usually don't do that. It is an old folk saying. Thank you, Sarah. Teaching a fixed to it's kind of like, what was that other saying that we had never heard before about, I can't think of it, but it was something really weird. And we went on about it for a long time. Something about a billy goat and a maggot. A billy goat and a maggot? I don't know. Teaching a fixed fish to foxtrot sounds like a line of one of Tim Dorsey's books, possibly Atomic Lobster. Okay. I thought just maybe it was an old time Southern 3 billy goats and a maggot. Thank you, Callie girl. Always getting here with the information. Thank you, Danielle. The defense knew and held onto all of this info in the hopes that they had something to allow a new trial. This needs to stop. The judge must put a stop to this behavior. Why is it still going on? I wish I knew. I wish I could tell you, because I am just as flabbergasted as you are. This needs to come to a swift conclusion. Hi, Scott. The red cow was a new one to me. Yeah, I don't know what they were talking about either. What was the red cow witness or the red cow juror? I don't know. It's kind of like the egg lady juror in the Murdoch case. But I don't know. Yeah. Jennifer, not funny at all. Yeah, Keith Richards is still alive too. So, 3 billy goats and a maggot, Ruby. That is exactly what it was. You are correct. Team Brittany's with Johnny right now. He's fine. You go, girl. You go. All right, let's go back now, shall we, and take a look at some of the misrepresentations that we saw in court that are referred to in this motion by our friend Ethan Shapiro. Let's see if we can find some of the things that they're talking about here. We did not watch this together, so I just wanted to point out how grown up that I think Maya looks here. And also, the audio is horrible on this. It's horrible. So I put the closed captions on. You know as well as I do, they are not always accurate in any way, shape, or form, but we are going to do our best. You may need to turn your volume up. I will try and speak a little more quietly. Here's Maya, Jack, and Kyle. This was last week on December 15th, which I believe was Friday. And as they pan, we will see Dr. Joe Corcoran sitting behind them. There he is right there, looking dapper as always. If you have not subscribed to Dr. Joe Corcoran's channel, you can find him at CMO Dr. Joe on YouTube. He may have the record for gaining most subscribers in a 48-hour period. I think he was up to 10,000 subscribers in 48 hours.
Just give me a moment to get the computer going.
Already not sounding like his usual happy self in the morning. And we know why.
This is case number 2018 CA 5321 Kowalski versus Johns Hopkins Children's Hospital. Starting with the plaintiff, let's take appearances, please.
Greg Anderson, Nick Whitney, also we have Tom Elliott and Amy Ferrier, and then by Zoom, Samantha Lawrence and Jennifer Anderson on behalf of the plaintiffs. Howard Hunter with Chris Altenberg, Ethan Shapiro, and Pat Crowell for Johns Hopkins Children's Hospital.
Thank you. And I assume everybody got the agenda that we're going to follow this morning in the second amended order. So why don't we just get right to it. First topic is going to be the issue of alleged juror misconduct, whether we should be having a hearing, and if so, what the contours of that hearing would be. Mr. Shapiro.
Yes, may I first?
Yes, sir.
May it please the court, Your Honor, I actually break this down into two separate and distinct arguments, either of which would warrant a new trial and at a minimum warrant the juror interview. The first is the duty of jurors to adequately and honestly disclose during voir dire any material issue that could affect their jury service. In this case, juror number one has 3 material omissions or misrepresentations based on his verdict form, and I'll discuss all 3 in turn. The first was he was asked on his Juror interview question whether he or an immediate family member had ever been a victim of a crime, and he checked no. We've since discovered that both he and his wife had filed an affidavit and prosecuted their stepson for threats and looks like what was being threatened as a murder of both of them in the form of a sworn affidavit to Detective George Richards on March of 2016. There's very detailed statements about this. I think they're part of the record, but if not, if I may approach and hand Your Honor a copy. This cannot possibly be something that a juror.
No, it cannot be possibly something that a juror didn't do because he checked yes to question 18B. I got to rewind that again. Hold on a second.
If not, if I may approach and hand Your Honor a copy. This for threats, however, a new trial and at a minimum warrant the juror interview. The first is the duty of jurors to adequately and honestly disclose during voir dire any material issue that could affect their jury service. In this case, juror number 1 has 3 material omissions or misrepresentations based on his verdict form, and I'll discuss all 3 in turn. The first was he was asked on his juror interview question whether he or an immediate family member had ever been a victim of a crime, and he checked no. We've since discovered that both he and his wife had filed an affidavit and prosecuted their stepson.
Okay, so I'm looking at the juror questionnaire right now, and 18B is broken down into 3 parts, A, B, and C. Have you or a member of your immediate family been A, victim of a crime? He checked no. Charged with a crime? Yes. Witness in a criminal case? No. So whether this is considered a crime, we will see. But the fact that he's bringing this out in open court is kind of gross. But, you know, why should we expect anything more or less?
For threats and looks like what was being threatened as a murder of both of them in the form of a sworn affidavit to Detective George Richards on March of 2016. There's very detailed statements about this. I think they're part of the record, but if not, if I may approach and hand it.
This is not part of the record. It's not at least published on the court docket. If anyone has seen this affidavit and you know that it's there, just tell me what document it's in because I have it open, the court file. I just do not see that affidavit that he is now handing to the judge that he handed to the plaintiff's attorney while he was making this argument. Not before, while.
Your Honor, a copy. This cannot possibly be something that a juror would forget to disclose. This was a question directly asked. And as Your Honor and the court would review the affidavit, there's multiple instances in here where both juror number 1 and his wife state that their safety is at issue, that there were threats made against them that they wish to prosecute. That's certainly something that if disclosed, there would have been multiple follow-up questions and likely a peremptory challenge used. The second is one that we did make part of the court record. Obviously, we apologize for the sensitivity of this, but we have to make it as part of the record that in 2002, juror number 1 was served with an injunction for a domestic violence of which there's a sworn affidavit of child abuse.
Again, to question 18B, have you or a member of your immediate family been B, charged with a crime? He checked yes to that box. Witness in the case? No. The time for questioning him about this issue would have been during voir dire, not in open court, in a blatant attempt to disparage a man's reputation who just served his civic duty. It's gross.
That file is obviously sealed, so I can't see what the allegations are, but they are part of the record. That would be something that they would have a duty to disclose both during the questionnaire and during voir dire. This was never disclosed, as Your Honor can imagine. Had that been disclosed, that certainly would have led to a cause challenge, if not a peremptory, if the cause challenge was denied. The third, we had learned.
20 years prior to this trial?
Yes, Your Honor. The third was in the questionnaire prior to the one given to the witnesses. There was a list of witnesses that may be present, of which there was Deborah Salisbury. Deborah Salisbury, as we've learned and as we filed with the court, it turns out she was juror number one's wife's attorney for her divorce proceedings, the same attorney who represented Mr. Kowalski. That was never disclosed to us either.
Yeah,
The
and
case
guess what
law on this
else,
is very
Shapiro?
clear.
Guess what else, Shapiro? Deborah Salisbury
and the
didn't
ruling-
testify in this case. After all, what difference does it make? And how is he supposed to know or have any knowledge of who his wife's attorney, his current wife, by the way, because they were not married at the time, obviously. This was a different matter somewhere back in like 2007. How's he supposed to know that his spouse's attorney was Deborah Salisbury? Is that something that everyone in this chat knows? That if you are married to someone who's been married before and had a divorce proceeding or any kind of proceeding, you would know who their lawyer was necessarily? I don't know. Tenuous at best.
0.431, we're entitled to an interview of the juror if there's a reasonable basis, and I'll get back to that. But I think the controlling case on this that's really undisputed is the De La Rosa case for the Supreme Court of Florida at 659 Southern 2nd 239. There's a three-part test utilized to determine whether a juror's non-disclosure of information during voir dire warrants a new trial. The first part of the test is that the complaining party must establish that the information is relevant and material to the jury, to the jury service in this case. All three would be material and relevant, but certainly in a case where there's allegations of medical child abuse and a juror has been served with an injunction for child abuse, that's something that we would have to know about. Certainly being a victim of a crime, especially one involving one's family member, would be something we would need to know about, and both of those were withheld from us. The second test.
Let me ask you this.
Yeah.
And I haven't gone back to look at all of the juror questionnaires, but were there other juror questionnaires where the juror checked family members been a victim of a crime, and then did your side ask questions of those individuals?
I haven't gone back through all the voir dire, but
Yes, I haven't gone back through all the voir dire, Your Honor, because I don't even have the transcripts for the voir dire. This is a disingenuous misrepresentation, and as an officer of the court, I submit to you that this could be a problem.
Well, you're making a statement, a very express statement that you would have used a peremptory challenge. And I'm just wondering if it was so important when that question was asked for other people, what did you do?
the law on what I'd have to go back to my voir dire questions and see what would happen, but I know that in each individual, for the questionnaire, all of these were asked by the court, if you recall.
Yes, and what did you do? You said nothing. You said nothing to all of those people who ended up on the jury. You asked no questions, despite the fact that you had a probably very highly paid jury consultant, like Bull from the TV show. Michael Weatherly played Bull. Sitting with you, you asked zero follow-up questions, and we have the receipts. We've got the receipts. Did you think plaintiff wasn't going to pay the $7,500 for the copy of the transcript? Is that what you thought? Is that what you were banking on here?
And that the court asked those questions. If we had follow-up questions during the individual sessions, we would have asked them if it was material to the case. Certainly if...
You would have asked them, but you didn't. This is really bad. Yes, this is from the other day. This is the motion hearing. Glow. Your question went by so fast. This is the motion hearing from Friday. So I have not gone over this with my viewers yet. And what we did is we went over the plaintiff's response to what happened on Friday first. And now we're going back and now we're going to catch all the lies. This is the fun part.
Somebody was saying they were a victim of a crime involving another family member. I absolutely represent to the court. That would be something I would have followed up on. With no basis to. And in fact, the case law says under both State Farm Mutual v. Lawrence at 65 Southern 3rd 52 and Westgate Palace v. Parr 216 Southern 3rd 747.
Got it. I got it, Ruby.
The counsel is not required to delve further into questions on the questionnaire if the answer is no. So there's under the three-part prong of the De La Rosa test, with the third one being whether a juror's failure to disclose information was not attributable to my lack of diligence. The case law on this says that if there's an express no to the checkbox, there's no duty on behalf of counsel to further investigate that question. So we believe we've met all three prongs under the De La Rosa test. And on this specific issue, since all three are material, especially the ones involving child abuse, and especially the more recent one involving a very serious allegation that both he and his immediate family member, being his wife, were victims of a very serious crime by another family member, the failure to disclose that at the front end is sufficient to award a new trial. So that's my argument on the non-disclosure. And at this point, Your Honor, I would switch gears to the argument about what we would phrase as improper influence, if not jury tampering, from the outside. And so, we put together a very detailed PowerPoint presentation that we
put together a very detailed PowerPoint presentation that we pulled directly from Reddit, Your Honor. So we can't really speak to its truth or veracity because we haven't really checked our sources. But we think that everyone on Reddit who's on our side is 100% factually correct. And so we're going to use it, Your Honor. And the reason that we didn't do it before is because, well, we didn't see it till after the trial is over. But next time, what we're going to do is we're going to get into all the subreddits before the trial, and we're going to ask them to do their investigation for us so that we can have all this stuff for you in a timely fashion. Okay? Thank you.
Filed as part of our motion for new trial regarding the social media postings of juror number one's wife and how those correlate to what we believe is a very real belief that that information influenced and was known to juror number one during his deliberations.
Wait, he said that he has a very real belief. Oh, well, if he has a very real belief, I mean, then, I gotta hear that again.
Is a very real and how regarding the social media postings of juror number one's wife and how those correlate to what we believe is a very real belief that that information influenced and was known to juror number one during his deliberations and during the trial.
It's a very real belief, according to who? According to your Reddit friends? I mean, according to who? What about Shapiro, Mr. Shapiro? What about the posts of you and your wife during the trial? What about that? What about that? What say you about that? Very real belief.
This has been noticed as non-evidentiary, I understand, so I'm going to try to move along. I didn't bring the PowerPoint to run through it.
Oh,
it's been filed with the
oh man, we wanted to see the PowerPoint. We wanted to see the PowerPoint. How dare you not bring the PowerPoint?
But I do want to lay for the record the timeline of this, because I think if the court sees the timeline of this, you can see that the alarm bells are really ringing. If we go back, even if you start with what we filed as of record, the juror question that was filed on October 12th with the Sally Smith's name spelled in the SS logo, and we filed that with the court, we're not accusing juror number one of being a Nazi.
No, we are accusing him of knowing enough about Nazi symbolism that he must have thought Sally Smith was a Nazi. It absolutely was not the KISS logo, Your Honor. We don't think he's a KISS fan. We think it definitely must be part of the Schutzstaffel. Now, Carol's going to spank him. Listen.
Every single,
logo, and we filed that with the court. We're not accusing juror number 1 of being a Nazi.
let me ask you about
yeah.
And also, Your Honor, the timing was a little unfortunate, being that we happened to file this non-accusation about juror number 1 being a Nazi in the court file on the first night of Hanukkah, Your Honor. A little unfortunate, I know, but hey.
every single juror question. My habit was to read the question at sidebar, and since I'm right-handed, I would use my right hand and turn it over, and almost always I handed it directly to you to look at. And so not only did you hear the question, you had the opportunity to physically look at the sheet. And then about halfway or 2/3 of the way through the trial, your side asked for a copy of all the juror questionnaires. That same day, I had the clerk provide them to you. So you had them. So why was this not addressed in your motion that was made? You know, you waited a couple weeks, but then you made a motion to disqualify the juror, but said nothing about this. So how is it that this issue isn't waived even before we get to the merits of the issue?
We frankly did not appreciate the difference in the lettering, Your Honor. Had we appreciated, we would have raised it.
I don't understand what you mean. You couldn't tell that the S was different than other questions, or you didn't know that this was in your mind, what you're so definitively saying is evidence of juror number 1 calling Sally Smith a Nazi. So, I mean, what is it?
He's trying so hard not to laugh. Can you see? Look at his face. Which is it? You couldn't. He's got a photographic memory. He remembers everything that he did with every juror note. His custom and habit was to hand it to him with his right hand. You saw it first, Shapiro. Every single time you saw it first. So why didn't you bring it up then? That is a great smirk. Jason Smith, are you here? Jason Smith, we need a meme. The judge Hunter Carol, stare down. And wait till you hear what Shapiro has to say here.
Well, with respect, Your Honor, I don't think anybody, including the court, appreciated the difference in the lettering in the moment. Had we done so?
Well, your second supplement is extremely definitive. And so I'm wondering, 1, why is this issue not waived? And 2, what is the good faith basis for the statement and the assertion you made, or actually Mr. Hunter made in the motion?
Yeah. Where is your good faith basis as an officer of the court? You need to have a good faith basis for everything that you are saying is factual. And you are not to file anything frivolous or untrue or baseless. Where's your good faith basis? Backpedal, and go.
What other plausible explanation would there be for distinct lettering for Sally Smith, especially in the eve of Mr. Anderson giving interviews to Court TV accusing the defense of following the Nuremberg defense of we're just following orders? Had this been only an isolated situation where one juror question has different lettering in the absence of any other suspicion of hostility, we may share this court's view that that would be an extrapolation. But
my recollection is that you all made a big stink about Mr. Anderson's interview that next day, and we had to talk about it and discuss it. So I don't see how you can say you didn't appreciate the issue when you physically saw the questionnaire and you were later given it during the trial. So why is this issue not waived?
Why is this issue not waived, is what he's saying. Not weighing. It says weighing on the captions. Why is it not waived, as in you waited too long to make this argument? And now he's going to lie to us again.
These issues are, from a legal standpoint, a procedural standpoint, the motions for new trial and requesting a juror review are preserved as long as they're brought within 15 days. There's no legal obligation that we can see that all of these issues need to be timely brought during the trial. Now, certainly, Your Honor, had we appreciated it, we would have added it to our motion. But given the breadth of it, I did not appreciate the different lettering at the time. That's all I can tell you. And it sounds, I don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how did you come to appreciate the difference?
Somebody pointed it out to me.
Bam. Somebody pointed it out to me on Reddit. On Reddit, Your Honor.
You can continue.
He's just like, really?
On October 19th, we put a lot of the social media postings of juror number one's wife. And look, spouses of jurors are entitled to opinions. That's not the issue. The issue is a lot of what's posted here. And I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff. That's not even the issue directly here. The issue is.
And your wife's posts were completely pro-defense. Kind of like you better want what you wish for here, because you're slipping into very slippery territory. This is a very slippery slope that he's about to walk into. Slide down.
Given the hostility of juror one's questions and timing his questions to what she's posting online gives a very strong presumption that they were communicating. Starting on October 19th, juror number one's wife was posting online about the lineup for the next day that included Detective Stephanie Graham. And then the next day, when Detective Graham's on the stand, she's posting in real time on social media that her husband's going to have questions for Detective Graham.
No. Lie. Jules, I don't know if you're counting. She didn't say, my husband is juror number one and he's going to have questions for Detective Graham. To my knowledge, hippo lover, wife of juror number one, never identified herself as wife of juror number one. Nobody knew that she was wife of number one. And I submit to you that she has a right to have a life. Oh, and there's also this thing. Oh, and she's also entitled to opinions, even though she may just be the household companion of juror number one. There's also this thing called spousal privilege, where spouses can't be forced to testify against each other, even in this little proceeding, Shapiro. So I'm not quite sure how you think you're going to get around that, or if you're even going to have your request granted for the judge to interview juror number one's wife. But, keep stretching, like Stretch Armstrong. Anybody remember Stretch Armstrong? That doll that you could pull or, Gumby.
Well, let me ask you about this. Because anyone who was at the trial knows juror number one was basically going to ask questions. Maybe not as certain as death and taxes, but probably as certain as there's going to be a traffic slowdown on I-4 around the Disney Champions Gate area. So how is that evidence of inside information?
Judge, again, if this is the only instance of juror number one's wife predicting who he's going to ask questions to and when, again, in isolation, if that was the only issue, I would appreciate it. But as we lay out, there's about 15 more instances that combine with it. Again, in real time, I appreciate the court shared the email from the woman from South Africa questioning the integrity of the Kowalskis. We call her the agent, regardless of what she is. She's, you remember Jules in the courtroom. She's been online saying she was texting with Maya, texting with the Kowalskis. She's calling into YouTube blogs and saying what the jurors are thinking. And, that email was shared with the court.
Saying what the jurors are thinking, because not only is Jules an agent of the plaintiff, but she's also a psychic. She's a psychic. Jules, did you forget to tell us that you're a psychic? We all knew that because there wasn't a day that went by that juror number 1 didn't ask questions. We all knew that too. And we were watching at home and we knew. And yes, somebody from South Africa did write to the judge, and it's in the court file, and sent an email and said, I just want you to know that there's a woman in the courtroom and she's sending this information and she's talking to a YouTuber, this guy named Recovery Addict. As we know, in the United States of America, courtrooms are open to the public. There's nothing wrong with that. There's nothing wrong with her. I can't get this glare out of my face. That's why I usually stream at night, but there's nothing wrong with that. She did nothing improper. But, let's bring it up once again in open court, Shapiro, because really you got nothing else. You got nothing else.
The court shared it with us, but as part of the email, when you look at it, she's talking about juror number 1 shaking his head hostilely towards the defense witnesses, that Jules is calling into the talk show saying that
Talk show.
that they're hostile to all of the defense witnesses. And, you get to what I think is very glaring was the October 26 questions when Sally Smith's video was played. I'm sorry, when Sally Smith took the stand. If you look at what juror number 1's wife is posting online at that point, and she is, again, I don't need to establish the pro-plaintiff bias, but it's concerning to the defense that when you look at her social media follows, it's not just the pro-plaintiff blogs. It's the Take Care of Maya producer. It's Mr. Anderson's jury consultant. And she writes on October 27th, I think Sally Smith only relied on Tampa General to decide this case. At the same time, her husband's asking the same questions that Your Honor may remember Mr. Anderson was complaining to the court. We need to clarify that the 2015 Bonnie Rice call was different than the 2016. When you look at his questions, they are, quote, why would Dr. Rice, a TGH doctor, need to call you, Sally Smith, about Maya when you're over at ACH? And then he asks the second question, why is Bonnie Rice calling you to raise the red flag? They're sharing the same questions and the same concern and the same confusion. Again, when you fast forward.
Well, from a timing perspective, didn't juror 1 ask the question first, and then there were comments from, I don't know what to call it, the public, trying to discern what the question meant?
They were made at the same time, yes, right.
Which one was first?
Which one was first, the chicken or the egg?
I believe his questions were first.
Oh.
So assume that the statement was from somebody other than the wife. If someone sitting in the gallery observes a question and then comments in a public forum about the meaning of it or the questioning of it, how does that show inside information with the juror?
Because it's a discrete issue of sincere confusion that they both share on the same topic. And
Okay, I have to rewind that because now he's like into the word salad. This word salad is so tossed, it's like insane. But Ozark Ladies Creative Moods, Mary, the talk show that they're referring to is the Recovery Addict YouTube show, which had the live stream of the trial every day from the Zoom feed, which was far better video than some of the other law networks like Law and Crime and Court TV. And so that's where we all watch this trial every day. So Jules did call into the show on occasion just to tell us what was going on in the courtroom. But she couldn't tell us what the jurors were thinking because she's not a psychic. She forgot to bring her crystal ball with her to court.
With the juror.
because it's a discrete issue of sincere confusion that they both share on the same topic. And, again,
it's a discrete issue of sincere confusion that they both share on the same topic. If anyone can translate that for me, please tell me. what that means? So they must have been, everybody was confused.
Under the totality of the circumstances, as the defense is looking at this
Hmm.
in retrospect, it belies credibility that the two of them share the same confusion on the same topic with absolutely no communication. And, because of the time limitation, I just want to fast forward to the part that I really think is concerning. We filed a video of the court of juror number one's wife sitting next to Jules in the courtroom. Again, this justice system requires not just obviously that the jurors be sequestered from outside information, but it requires the appearance that everybody participating in this tribunal is fair and impartial. I find it impossible to believe that.
Look at Judge Carroll's face. He's got his hand over his mouth. He's like, I cannot even believe that I'm hearing this right now. He just wants to go like this. No, 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 no. I don't hear you.
And I'll say that the Kowalskis didn't know at that point, because Jules is texting with him and communicating with him, that she didn't just spend the day with juror number one's wife. And that when we made the motion to disqualify juror number one for our feeling that
Jules did not know that that was juror number one's wife. I'm just going to say it. Jules did not know that that was juror number one's wife. There were many court watchers in the courtroom every single day. And yes, if you're sitting next to someone, you may chat with them. Juror number one's wife did not disclose that she was juror number one's wife. Okay, there. Are you happy? People in the courtroom are not allowed to talk to each other. Is that what you're going to say next?
he was no longer fair, that he was no longer impartial. Somebody has a duty to let the defense and the court know, hey, by the way, his wife was in the courtroom. She's posting online saying, my new best friend is Jules. She's posting in chat rooms saying,
Jules, I'm sorry they spelt your name JWES. I apologize on the behalf of the closed caption robot.
to one of the bloggers, check out the burner phone with regard to information we have about the Heart Institute. And they're making plans to go to dinner. I mean, at some point, just the appearance of the foreman of the jury's wife sitting in close contact with the agent of the Kowalskis is wrong.
What about the appearance of you and your wife on social media? Telling your redditors to help find you dig up information. Calling the jurors bus stop people. What about the appearance of that? What do you think is more important, my friends? What say you? The appearance of two women sitting in a courtroom watching a trial because they like to do that and they have the time and the ability to do that, and they're interested in the United States justice system and may have been interested in this case, or the appearance of the defense attorney and his wife and his partner who's calling the jurors bus stop people. What if we're weighing the evidence here, what do we think is more important appearance-wise? Because as an attorney, you take an oath to avoid the appearance of impropriety, the avoidance of impropriety. Thank you, Skoda. Thank you for coming in with the voice of reason. Methinks thou dost protest too much. Weigh. I'm going to say weigh. We're almost done with him because he's almost done with his argument. So,
and the idea that this can go on unbeknownst to the defense and known to the plaintiff, that ultimately culminates in a motion that we brought in, I believe, November 6th, asking for the disqualification of juror number one. And Mr. Anderson, as you remember, went back and forth on it. I think I'd have to agree with this. You asked him, in fairness, Your Honor, do you want this as an appellate issue? And Mr. Anderson said, no, I'm going to substitute in the next juror. And then he went to Mr. Kowalski and said, they had a conversation. Obviously, we're not privy to the conversation. He said, based on the conversation I had with my client, I have to go with his wishes and keep him on. At that point, we believe it has to be clear that they knew that his wife was in the gallery.
No, at that point, what was clear is that we saw, Mr. Shapiro, your people, your attorneys doing this, sitting behind your defense table with excitement. They could not contain their glee with their jazz hands and their fist bumping and palpable glee at the fact that Greg Anderson said for a split second that he would consider replacing juror number 1. That is what was evident. And I can't believe nobody's brought that up. And to my knowledge, nobody still has brought that up. And tell me if they have brought that up about the jazz hands and the glee and the all of the reaction from the defense. Maybe maybe it was your own damn fault. You blame everybody but your own damn self and your own damn people. It's everybody else's fault, but not mine, Judge.
What Jules may have told them about what conversations she had, we don't know. But we're entitled to an interview on this subject to find out.
Let me ask you.
Wait. You're entitled to an interview, Jules? Oh, wait, stop. Oh, for the love of all things holy and the traveling Mary. Oh, for the love of traveling Mary. Hold on a second.
Was in the gallery. What Jules may have told them about what conversations she had, we don't know. But we're entitled to an interview on this subject to find out.
No, you're not.
Let me ask you this. Assume for the sake of argument, I agree with you that from an appearance standpoint, or maybe the cumulative nature of the instances that you have laid out, suggests we need to have an interview. What type of parameters would you recommend be for that interview?
Right. And Your Honor, honestly, I've never had to make this request in my 20 years as a trial lawyer. I will say I understand what we're asking for and the consequences of this. I completely understand.
Do you?
The need to respect.
Do you understand the consequences of decimating the entire jury system in the United States of America? Do you understand the consequences of that? That every juror and his wife and another woman sitting in the courtroom watching the damn trial will have to turn over their electronics to you?
The judicial process and the jury process and not pry into their lives. I've never called a juror. Obviously, that would be improper and illegal. Their deliberations are theirs, but in a situation like this, with the totality of what's going on, we obviously need not just an interview to see who said what to whom, but the problem is either one of them could just frankly say, well, we didn't talk, and that can't be the end of the inquiry. I would like to know.
Yeah, that needs to be the end of the inquiry. Because if juror number 1 raises his hand and swears to tell the truth, and the judge says, did you discuss this case with anybody? And he says, no. Did you do any outside research? And he says, no. Just like they asked that jury, he asked that jury every single time they came into that courtroom. That has to be the end of the inquiry. This is really, really such a ridiculous.
Since juror number 1's wife and Jules were in close contact, apparently new best friends, texting about the trial, talking about boyfriends, I'd like to know what the communications were.
Really?
And, again, I know it's a big request.
It's a big request to know what the communications between a woman that nobody knew was juror number 1's wife and a courthouse observer named Jules. We should know. You have the right to know what their communications were. Okay, big brother. This is a Shonda, you guys. This is a Michigas. This is I can't even believe that he has the absolute courage to get up there and argue this in open court. I am embarrassed to be a lawyer today. I was embarrassed to be a lawyer the day that this supplemental Schutzstaffel information was filed with the court. And then again today, when he handed them that affidavit in court with regard to the stepson of juror number 1, I am horrified to be a lawyer. This is disgusting and gross. And that's what I say.
But we'd like to know what text messages were going on between them. If the court wants to view them first and, look at them and decide, is there anything there? And you can tell us. I don't know any other way to do this because otherwise, he at least according to his own social media posts, he's been in contact with Mr. Anderson, who's told him not to say anything. So he's lawyered up to that extent. He's going to be.
He's lawyered up to that extent.
I'm not suggesting the plaintiff's counsel would ever say to him anything other than tell the truth. I'm not. But he's been lawyered up at this point and advised multiple times that if you say the wrong thing, you're going to throw out this verdict. So I don't know that we can just rest on the assumption that if the court were to ask a series of questions, did you consider any outside influences? Did you hear anything? If we get frank denials at that point, that would satisfy the inquiry. In this age of social media where where our primary concerns came from social media, we believe that the proper remedy would be some type of inspection of electronic devices to see if communications were made between him and his wife regarding the trial.
You are insane, dude.
Between his wife and Jules or other agents of the Kowalskis, and to see what they're talking about. Because of course, if there's a text message that's going on between, for example, juror number 1's wife and Jules that says, don't worry about this, he's going to vote for you, that would be massive, and that would be grounds for a new trial. So our request for this would be the interview. We would certainly defer to the court to the grounds. We're not looking, we suggest it would have to be on the record with people with the chance to examine it, but we believe there has to be some type of an inspection, and the court can certainly control it. We could draft what we would propose as an order if the court were inclined, and I would respectfully suggest that we've more than satisfied our burden under Rule 1.431 with my sworn affidavit, with the evidence we put forth here and more. And I would suggest that I would get with my appellate counsel, Mr. Altenberg and Mr. Hunter, and draft a proposed order that would encompass what we believe would be the scope that would include not just an interview, but some type of an inspection of electronic devices.
Thank you, Mr. Shapiro. Who from the plaintiffs?
Wow. If please support, we'd like to appropriate.
I don't think that we need to watch any more of this. I just wanted you to see the blatant lies and misrepresentations that were made on behalf of the defense. JHACH. Darlene, I've been saying this for weeks. SNL, are you watching? Please do Shapiro as a skit. Give him cause for a motion that SNL made me funnier. I think that are you guys SNL watchers? Because I don't know if we are quite their demographic. I do tape it and watch it because I still think it's funny. I don't know if it's widely known enough for them to want to do a skit about, but they do a lot of skits about a lot of things that I don't know about. So, happy birthday, Miss Justice Jones. Friday was my birthday. I was excited to watch this case. I'm frustrated with being able to hear it and or the recording issues. I know I'm getting old, but I really felt like my hearing was gone. Well, happy birthday to you. And I'm sorry that you had to suffer this terrible, terrible audio. One step beyond you, this guy has just elevated social media above objective reality. Yes, and that is true, my friends. That is true. Team Brittany, again, you gifted 5 more memberships. You are amazing, girl. Thank you so much for your generosity, and to all the new members who there's 10 new members today, thanks to Team Brittany. So she's one of my amazing moderators, and thank you so much. Angela, maybe the defense just needs a participation award. They clearly can't accept they lost. It is hurting their feelings. Lanana, 56. This might be a crazy question, but all those missing texts from the drowned phones, could they not be retrieved from the cloud? Could plaintiff subpoena those? I imagine that there would have been ways to do that. I would imagine that they tried every way that they could have. They seem to have spared no expense in the prosecution of this case and handling of this case. So I just don't know. I don't have enough information on that to know what happened with those phones. But Jester says, and that's why I highlighted this, Jester's Fabry Hospital's backup data, it is BS. They lost this particular info and the dog ate their homework. Kind of like those photos never made it into the medical record, and there were no observation notes made of that 48-hour diagnostic testing that they did in the room where they falsely imprisoned Maya, according to the jury. Kathy and Pam, West Virginia, the judge should be protecting Juror 1, HL, and Jules from any of the parties making harmful and false claims, along with doxing them at the same time. I have been very, very angry about this, Kathy and Pam from West Virginia. And I have been screaming about this since this information Since these filings first came about, I have been very, very angry. If you go back and watch the stream that I did on the Nazi motion, the Nazi supplement, I was mad and I couldn't take it anymore. And I had to calm down before it even came on camera. So I agree with you. D, hi D. Judge C needs to put a stop to this. If we see this injustice, Judge C has to see it too. He needs to act. This judicial strong arm, I agree. Nancy says we all love Juror 1 because we knew he'd ask the questions we all wanted answers to, and none of us lived with him. That is true. Dr. SB, sorry, the justice system is going to suffer here, and that is another thing that I've been screaming about. But as I told you at the beginning of this stream, the one shining light that has come out of this case so far is that Florida has changed the law, and effective on January 1, the 7 counties in Florida that previously had privatized DCF systems for investigating CA cases, including Pinellas County, where this cause of action occurred, are no longer going to be private. And they are going back under state control. So that is one thing that is good that has happened from all of this. Judge also issued another order, I believe it was this morning. And I believe this is the one. Yes, it is. Look at me getting really good with all of this technical stuff. I believe this was also filed this morning and or late last evening. This is an order that is a judge. The judge, sua sponte, on his own, has asked and signed this order requesting the transcript concerning individual questioning during jury selection. Yesterday afternoon, plaintiff filed its response to defendant's third supplement proffer of affidavit as at December 15th hearing. That is the motion papers that we just went over before we watched Mr. Shapiro in court. To motion for juror interview. Footnote 6 at page 9 of that filing suggests there may be a transcript from the individual questioning conducted during voir dire, the one they paid $7,500 to get. To the extent that there is a transcript from the individual questioning days 1, 2, and 3, September 14, 15, and 18, the court would request that a copy be sent to the court's judicial assistant as soon as possible. The court is most interested in the second round of questioning based on responses to the questionnaires, and not the first round, matters primarily involved regarding financial hardship. If there is only a transcript for days 1 and 2, the court still would like for it to be submitted. The court is still attempting to have an order released on Wednesday. That would be this Wednesday, which is tomorrow. But that may be pushed to Thursday. Done and ordered in Sarasota County. That was this morning at 6:49 a.m. Judge Carroll is working overtime 24/7 on this case. I'm sure that he can't wait to get it off his docket. And this is just the affidavit of service showing that they served it on, that he served, that his clerk served this order on all of the attorneys in this case. He did not leave anybody out. He sent it to everyone. So he wants to see the transcript of the voir dire so he can catch perhaps Mr. Shapiro in a couple of more lies. And that will even make his decision on this motion stronger if he has that transcript. So that is a good thing. That is a good thing. And it also reveals to us that there were 3 days of voir dire, of jury questioning. It took 3 days to pick that jury, September 14th, 15th, and 18th. That, my friends, is a good thing. So what say you? The exhibits to that motion show some questioning of the jurors who actually wound up on the jury, wherein the defense did not ask any questions. Oh, Jules, I have so many thoughts. I don't even know where to start. He's asking for the transcript. That's a good thing. He wants to not look at portions of it because if we go back to the motion, which I guess we can do for 1 second because I have to leave shortly to pick up. Scarlett, if you're watching, I'm probably going to be late picking you up today. It's not my fault you're getting an early dismissal. Let's take a look for a moment at the exhibits to the motion wherein we look at some of the questioning. So this is the questioning on juror number 1. And you remember what Shapiro said, that he would have went further with the questioning if he said he was a victim of a crime, or been accused of a crime or convicted of a crime. And I will read this for you in my best voices. The court. Okay, anything else before we bring in the first one? Okay, let's get to juror number 1, and juror number 2 will need to be on deck, but it will probably be about 5 to 10 minutes from now. Okay, welcome juror number 1. Juror number 1 says greetings. The court, greetings. And as a reminder, we're only going to refer to you as juror number 1. Okay, so I'm going to ask you a series of questions, and then the attorneys are going to ask you questions, okay? And they're all going to go over the paperwork that you filled out earlier today, okay? I saw in the questionnaire that you indicated that you were charged with a crime. Can you tell me a little bit about that? Juror 1, no, I wasn't. Court, okay, and were you born in 1964? Juror 1, yes. Court, okay, and juror number 1, maybe I X'd something. The court, yep. Juror 1, one of my stepson was. The court, okay, but you have not been charged with a crime? Juror number 1, no. The court, okay, now in going through the rest of the questionnaires, I saw that you have had a close friend or family member that has died by suicide. Juror 1, yes. Court, okay, and who is that in relation to you? Juror 1, that would have been my current wife's brother. The court, and when was that? Juror 1, about 4 years ago. The court, now obviously I'm not going to tell you about what's going to go on in this case, but you might hear discussions about death by suicide in the trial. Is there anything about the fact that your wife's brother committed or died by suicide about 4 years ago, and knowing that's going to be something that's discussed during the trial, are you going to be able to lay your personal issues aside and focus in on the trial? Juror number 1, yes. The court, okay. Juror 1, he was kind of estranged, I guess you'd say. So the court, okay. Is there anything about either that particular case or death by suicide that you hold any sort of strong opinions about death by suicide? Juror number 1, no. Court, okay. Mr. Anderson, do you have any? Mr. Anderson. So in this case, if there was some testimony about one of the parties committing suicide, that your past experience is you could put whatever thoughts that came through your head at the time, set them aside, try the case based on the law and the facts? Juror number 1. Yes, correct. The court. Any other questions? Mr. Anderson, that's all. Mr. Shapiro, no questions, Your Honor. Ms. Cruels, no questions. The court. Okay, sir, I'm going to have you go sit back. It's probably going to be an hour or so before we get back to you, but if you could just make yourself comfortable. Again, do not discuss this case amongst yourselves. Do not do any. Juror 1, correct. Absolutely. The court. Thank you very much. Juror 1, have a good day, all. Court. Okay, number 1 is out of our presence. Are there any motions with respect to seat number 1? Mr. Anderson, not on behalf of the plaintiff. Mr. Shapiro, not on behalf of all children's. Ms. Cruels, no, Your Honor. Court. So juror 1 will go through to the group stage. Okay, let's bring in the next one, which is juror number 2. On deck is going to be juror number 4. Okay, so juror number 2, welcome. As you can see, Mr. Shapiro asked no motions. He had no motions with respect to juror 1 and no questions. And neither did Ms. Cruels, who I guess was on their team at some point because she did come to much of the trial. So they kind of had 2 bites at the apple there. They were kind of on the same team. Little disingenuous when he said he would have inquired further when he inquired, not at all. That's the juror questionnaire of juror number 1, which we have gone over at length on other streams. And here is another excerpt. And this is the questioning during voir dire of prospective juror number 14, who did wind up, I believe, on the jury. Mr. Anderson, having concerns is one thing, but another thing is, like you said before, compartmentalizing and dealing with things from a rational, straightforward basis. Judging it from that way, do you think that you can try the case based on the law and the facts? Prospective juror number 14. I could, yes. Mr. Anderson, but you think that maybe if the case moved more into some discussions of the Roman Catholic doctrine, you're concerned that there might be an effect on you. Prospective juror number 14. Yeah, you might lose me. Mr. Anderson, all right, thank you. Mr. Shapiro, any further questions? Says the court. Mr. Shapiro, no questions. Mr. Corrales, no. Court, okay, ma'am, if I could have you go back and sit, it might be another 45 minutes or so. And juror number 14 says, okay. Court says, okay, thank you very much. Okay, juror number 14 is out of our presence. Are there any motions with respect to juror number 14? Mr. Anderson, right up to the Catholic question, court says, so you're moving for cause. Mr. Anderson says, I guess. Court says, any objection? Mr. Shapiro, no. Ms. Corrales, no. Court, okay, so we'll ultimately excuse juror number 14, but we'll do that a little bit later. Okay, folks, we're at 2 o'clock. We still have 4 more to go in this group. So to the extent we can pick it up a little bit, we'll try, okay? 17 is next with 18 on deck. So I guess potential juror number 14 was dismissed on consent. Here's prospective juror number 17. Hi. Court. And again, we're going to use only your number as opposed to your name. I'm going to go over your paperwork and questionnaire, sir. And this might be kind of a missed check, but on your sheet, you said that you could not write the English language. Juror 17. Oh, I can write the English language. Court. Okay, that's what I thought since you filled out the full paperwork. There was also an indication that either you or a family member had been charged with a crime. Juror 17. Yeah, I think my son was arrested for drinking and driving. Court. Okay, but that wasn't you. Juror 17. No. Court. And when was that arrest for your son? Juror 17. 5 years ago in Massachusetts. Court. Okay, you indicated that you had a close friend or family member that died by suicide. Can you tell me a little bit about that? Juror 17. It was a friend. Court. Well, a close friend? Juror 17. No, not yet. I would say close friend, neighborhood kid. Court. And how long ago? Juror 17. I would probably say about 4 years ago, 5 years ago. Court. Now there's going to be testimony about death by S in this case. And knowing that you had a neighborhood kid that died by S, about 5 years ago, are you going to be able to put that situation aside and focus only on the evidence? Juror 17. Oh, 100%. Court. So whatever the evidence in this particular case is what you're going to focus on in and not that other situation. Juror 17. Definitely not. Okay, Mr. Anderson, do you have any questions? I don't believe so, Judge. One moment. No questions, Judge. Mr. Shapiro. No questions, Judge. Ms. Corrales, just a couple. When that you said 4 or 5 years ago, juror number 17 nods. Ms. Corrales, when that happened, was there a discussion as to what caused him to do that? Was it a man? Juror 17, it was a man. Yeah, I mean, I was shocked. I just heard about it. And Ms. Corrales, so you weren't involved in any major discussions? Juror 17, no. Ms. Corrales, with people as to why it happened? Juror 17, distant. Ms. Corrales, okay, thank you. Court, okay, thank you, sir. If you could go. And then there's some other juror questionnaires. And again, I'm talking about juror number 18. Who talks about this person is an experienced nurse. Anderson asks if she's confident that she could hear evidence about any problems with the case by a nurse and your prior experience would not affect your ability to judge that. Juror 18 says, no, I don't think so. Mr. Shapiro, no questions. No motions from Johns Hopkins. No motions at this time. They accept her as a juror, I believe. Here's another one who said they had a close friend or a family member die by S and that they have some opinion. But I think what we're looking for is the crime questions. This is all to point out. Oh, here it is. Okay, let me ask you this. I see that you've also talked about a movie called Take Care of Maya. I don't think you've seen it. Is that correct? Juror number 19, I have not seen the movie. I've seen trailers. The court, okay. Number 19, I have to think about that because the name sounded really, really familiar and I don't always remember the names. And when I think about it, I think about the storyline if I'm thinking the same movie. Court, so you have not seen the movie. Juror 19, I have not seen the movie. Court, have you had discussions about the movie? Juror 19, my sister was telling me about it, but not, I wouldn't say discussion. It was just, hey, I saw this movie and that was kind of the end of it. It happened in Florida and blah, blah. That was pretty much the end of it. The court, I see that you're also strong. You have strong opinions about religion and the Roman Catholic Church and that you do not believe in death by S. Is that juror 19? There again, I was thinking it was death by S given a medication to die. The court, like euthanasia. 19. Yes. I was born and raised in the Catholic Church, so there's just some of the beliefs that I do believe in. S is just a very sad situation. Okay, Mr. Anderson. Mr. Anderson, I take it from your answers then that if you could decide this case based on the law that the court gives you and the facts just from inside the courtroom and put aside any other knowledge or exposure of things outside of it. Juror number 19, I think so, yes. Mr. Anderson, and you could remain impartial as to both parties. Yes. Mr. Shapiro, hello, juror number 19. Juror 19, hello. Mr. Shapiro, so a couple things. On one of the boxes that you checked, have you read any of the stories in print or media about take care of MK or this case? Either your handwriting is as bad as mine or, oh, that's a great way to insult the juror. Juror 19, no, because that's when I was thinking, no, I didn't see this. And then I thought, oh, I saw a trailer on this. When you're flipping through the movies on Netflix and you're just sitting there reading about it, and my sister had told me about it as well. And then I think I'm not in the mood to watch it, so I don't watch something like that. And then I go up on something else, and I never went back to it. Mr. Shapiro, and what do you mean you're not in the mood to watch it? Juror 19, if I don't want to watch a depressing movie or show, something that's shoot 'em up, I don't watch it. Mr. Shapiro, what do you know about the movie? Juror 19, not much. It was about a young girl, I think. She was sick, or maybe she wasn't sick, and she went into the emergency room a lot. And I guess the mother was accused of, basically was accused of child abuse or neglect. That's about all. I don't know what happened at the end. Mr. Shapiro, does the fact that Netflix made a movie about it give you a sense in your mind that perhaps the story has some merit? Juror number 19, yeah, I guess so. Mr. Shapiro, so before, and the reason I ask, I imagine you're flipping through the channels and all of a sudden there's a show, and now you've got the lucky number of having your lucky number called for the trial. Juror 19, yes, lucky me. Shapiro, that's why I was asking juror number 19. So before you hear evidence, do you have a sense in your mind that perhaps the Kowalskis have some merit to their story? That would be fair? That would be fair? 19, I don't know because I don't know the story. I feel for somebody that's gone through that, but I wouldn't. Who wouldn't really? I don't know. I really don't know. Mr. Shapiro, do you remember anything else anyone's told you about the story that we haven't talked about? Juror 19, no, not really. Shapiro, is it your cue of something that you would watch? Obviously, you wouldn't be able to. Number 19, no, it's not now because this was a while back when my sister was telling me about it. Then I move on and all these new ones come up and series come up and I get kind of involved in watching those. Mr. Shapiro, so just let me ask one more time. Because obviously it's you'll learn who represents you. I represent the hospital. It'd be very important to us. Obviously the hospital denies wrongdoing. That's why we're here. But it'd be very important for us jurors to come into this sort of blank slates, You know what I mean? Juror 19, And that's why I'm asking you, do you think having known there's a movie about this involving a local family, that gives them some credibility in your mind before you start hearing evidence? Juror 19, some credibility? Shapiro, yeah, like there may be some credibility to their story because it was covered by Netflix. Juror 19, no, I don't think so. Mr. Shapiro, let me ask you a little bit about, just really quick. I know what it is, politics, religion, don't talk about it, but we're talking about it. The Catholic religion, any sort of affinity for or against people that are also Catholic, kinship, anything like that? Yeah, let me ask it in plain English, right? Prospective juror, yeah, please. The juror must have looked very confused. Mr. Shapiro, so the Kowalskis are Catholic. It sounds like you were raised Catholic? Juror 19, oh, okay. Does a fellow practicing Catholic come into this courthouse asking you for your vote in a trial? Do they have some natural? No, nothing at all. No, I have a sister that's actually Jewish. So, she was Catholic. Mr. Shapiro, gotcha. Okay, I don't have anything else. I appreciate your honesty. Mr. Wells, Judge, no, I don't have anything other than juror 18. I think needs to be asked. Do you want me to ask? I'm sorry. Questions 18 on the front. That's all right. I'll ask. You mentioned that. Court, I'm sorry, you're right. The paperwork indicates you were charged with a crime or maybe a family member. Juror 19, family member. Court, okay, when was that? Juror 19, the most recent, just a couple months ago. Court, okay. He's not been convicted yet. He's in rehab now. It's my brother. The court, your brother, does he live with you? So this is just an example of how Shapiro was far more interested in knowing whether the prospective jurors had seen the Take Care of Maya documentary on Netflix and about their religion and whether or not they were Catholic or had any sympathies from the Catholic or towards the Catholic religion. Far more interested in those types of things during voir dire than he was about any of the questions involving crime or being victim of a crime or committing a crime. And I think that this is an excellent, excellent response. And it is time for me to wrap now, my friends. Just going to see if there are any more. Oh my goodness, Joanne Byer, thank you so much for your super sticker. I do appreciate your generosity so very much. I'm going to scroll through the bottom. Yeah, Nancy, all of us Catholics wanted to know what happened with the body of Christ. Well, it may have been dosed with liquid K, so it had to be confiscated. That was their story, and they're sticking to it. Sticking to it. Smile34, so glad to make this live. So glad that you were here to make this live too. Thank you. Thank you so much. Let's just go back. Jules, I'm so glad you were able to join us today. A recovery addict stopped in. I think Uncivil Law was here earlier. So we've had a couple celebrities in the chat today. BG. Shapiro was definitely scanning the room. I was there a few days and locked eyes with him when I was sitting behind Dr. Scott and chatting with him. Ooh, what was that like for you? Because when I was in the courtroom with the accused Long Island serial killer Rex Heuermann, he turned around and looked directly at me, and that was chilling. But, two different things. One's a lawyer, one's an accused serial killer, because innocent until proven guilty, as we say here in the LawTube world. And that is our credo. That is, everyone is innocent until proven guilty. So there we are. That's everything. I think we are caught up for today. BC Can. Anderson needs to introduce info about Shapiro comment to Jules about Get a Life. Do you think they were surveilling the gallery folks during the trial? That's gross. If so, somebody just responded to you there. And also, I think that was brought up. Was it brought up? May not be exactly what they said, that he told her to get a life, but that he did make some rude comments. I did think that was brought up. Hi, Lisa. He literally asked no questions. Yeah, that is true. Somebody's in all caps here. Tell me what you think in the comments, you guys. I need to run because I am a mommy Uber today, and it is almost 2:00 here in New York, so I need to do a pickup. I would love it if you would comment below, and please like this video, share the video. Also, feel free to subscribe if you like what you're hearing. It's absolutely free to subscribe, and we keep it classy here. So please, in the comments, no personal attacks on me, on each other, on the moderators, or on any of my guests, of whom there are none today, but let's keep it classy. I like to read the comments. I like to respond to them when I have time to do so. My moderators, thank you so much for keeping the chat classy today, and for, as always, the hard work that you do. I love you. My little cupcakes, my channel members, thank you so much for believing in me enough to want to join my channel. We are going to do a members only live before Christmas, so keep your notification bell set to all notifications. So if you are a channel member, you will get a notification on that, and I'm totally open to topics, whatever you guys want to talk about. I know that the other night when I did the stream that my mods asked me to set up to do the unboxing of the gifts, the stream turned into something really wonderful, and it turned into people who were opening up in the chat about how they were lonely during the holidays and they have so much trauma around the holidays, and about how so many of their family members were lost around the holidays, and that made it so hard for them to celebrate and to be joyful. And the way that you were comforting each other in the chat and in the comments after the live stream was something that made me tear up. And if you haven't watched that stream, you can, some of the mods came on camera to say hello. And you can, if you don't want to watch the gift opening, just fast forward through it, and we have a really great conversation about grief around the holidays. And I just loved how so many of you lifted people up during that stream. It was a beautiful thing to see. So I think we're creating a beautiful community here, and I love it. And I'm going to see you guys real soon. Remember, as always, Jeanette, it was awesome. As always, don't forget, be cool, be kind, be classy. It's not hard, you guys. Love you all. Peace out. I'll see you real soon.